score, particularly because it includes electronic information, that the type of information that an employer could acquire was not protected by this exception, was not limited just to information that was entirely private. And by analogy, we address two specific areas that are actually found in the GINA language. GINA specifically prohibits medical databases and court records from the protections of this exception. And the reason why they did that is because medical databases and court records are areas where the employer knows or should know have a heightened risk of having genetic information within them. Well, by extrapolation, we believe that that same rule should apply to all mediums, that regardless of whether the medium is potentially available to the employer publicly, that doesn't mean the employer should be using it as a tool for acquiring information. And in terms of the employment context, we felt it was important to include things like social network sites and areas where an employer might troll for genetic information or other forms, frankly, of information that they might use in the employment context. Generally, that's become, or it's becoming often regular practice among employers to start looking for alternatives when they are making inquiries about their employees to sort of the more traditional reference checking. And we've already seen in many instances of employers trolling for information on the internet and in other areas where it might be publicly available for private information about their employees that may not have been offered to them through more traditional channels. We believe that the language in GINA clearly prohibits that type of inquiry, and we felt it was important to make that distinction in the model comments.
All right, great. So a couple of these, this next question here is more with regard to, I guess I would say the definition of genetic services and really how that applies with more conversations with health professionals. The first is kind of a detailed question. How do you feel that genetic counseling, in your model comments, you specifically refer to genetic counseling either from a counselor or from a doctor. But genetic counseling is available in a couple of forms. I mean, right now with, nurses are available to provide genetic counseling as well, or at least provide education surrounding a similar, in kind of a similar vein. Do you think that that is something that we need to keep in mind, especially with genetic counseling, that we're able to keep it broad without unintentionally creating any barriers?
It's certainly true that genetic counseling increasingly is and has to be done by a wider range of health professionals, simply because genetic testing is becoming more common and there just aren't enough certified genetic counselors to do the work. It's just, I think, a fact of medical practice. I don't think that that affects the way genetic services should be interpreted for purposes of GINA. The idea here is that GINA is setting out to prohibit the employer, in this case, from discriminating based on something that they learn about the employee. The easy case to imagine is the employee has a genetic test result, and that is what the employer learns. But I think that the definition of genetic services and the inclusion of genetic counseling basically stands for the idea that if an employer learns that an employee has sought genetic counseling or sought genetic services or had genetic counseling or had genetic services, that there can't be discrimination on the basis of that fact. So the assumptions that an employer might make about whether an employee knows or believes that they are at risk for future disease, and that's the basis of the genetic counseling or whatever, the discrimination can't take place because the employee has had that genetic counseling. And I don't see a reason why you would want that definition, I think. I do think you would want that definition to be broad.
All right, wonderful. I guess a lot of our remaining questions are with regard to existing resources that are out there, or resources I think that even would be of interest to people in developing. Could both of you possibly elaborate on any, rather than having you right off the cuff explain the kind of correlations between GINA and ADA and that relationship, and you're certainly welcome to elaborate on that now briefly, or however you can briefly, but also with Title II and GINA and HIPAA, can you suggest any resources for our participants in wanting to learn more about those interactions?
Well, one thing that Jeremy and I have talked about doing over the next couple of months is creating some fairly straightforward resources for essentially aimed at employees, what you need to know about genetics and genetic testing and employment, which I think will help to synchronize some of those issues. And I'll let Jeremy talk maybe specifically now about whether there are resources that are out there in particular. But I do think that whether you're applying for a job or considering applying for a job somewhere, or genetic testing comes to your workplace in the form of a wellness program, there are a number of issues to be aware of. So I realize I'm not answering the question with resources. You know, I think all of us want to make sure we know what the law is. Now that we have the NPRM, we have a pretty good sense of where we'll end up, but it's obviously not final yet. So in terms of resources on the ADA, the EEOC does have a number of guidances and other documents on its website that I think are useful.
I would join Susanna in suggesting that anyone who's interested in learning more about the ADA in particular, that they do use the EEOC's website. They not only have quite a number of more general documents, but they have some quite extensive question and answer sections on the ADA, as well as other civil rights laws as well that listeners might be interested in. So I would suggest going there. Just to be clear in terms of, you know, GINA and the ADA and the way they might interact more, you know, generally, you know, many of the same language is employed throughout both in order to keep them consistent with each other in terms of how they might be used, and generally, GINA, of course, addresses situations where an individual is being discriminated against before there has been any manifestation of the underlying condition that might be associated with the gene. Once there is manifestation, ostensibly the ADA applies, although it's clear that there remains a group of individuals who could potentially be discriminated against because they have a manifestation of a disease who would still not be protected under the Americans with Disabilities Act, because that manifestation doesn't necessarily rise to the level that the definition of disability under the Americans with Disabilities Act entails, in which case there is still, of course, work to be done here to fill the gap between GINA and the ADA for those individuals. Nevertheless, that's generally the framework that we're faced with.
Okay, great. And then we just, one more real quick brief question, and then we'll wrap up. Is GINA retroactive for someone who lost a job due to a diagnosis in the past couple of months, or even due to I would extend that even more to due to an employer firing an employee because of finding genetic information? Is it retroactive?
No, it is not retroactive, and in fact, GINA hasn't even gone into effect yet. So somebody who was discriminated against today would still not have the protections of GINA until it actually goes into effect. Susanna might remember the exact dates, but I believe the Title I goes into effect later this year and Title II in the middle of next.
Well, Title I is a little bit confusing, but essentially we are supposed to have Title I regs in effect soon after May 21st of this year. Now, given that we don't have a regulation yet, it's not clear whether they're going to make that deadline or not. The Title II regs are going to be in effect November 21st of this year. Jeremy, can you comment, though, because this is not my area of expertise, on if somebody believes that they have been have lost a job or been discriminated against on the basis of genetic information? I mean, there are certainly other possible avenues. The EEOC, for many, many, many years, has said that the ADA includes genetic information. That's obviously an area of law that's somewhat in flux now.
Well, that's true, although in large part it was the lack of belief that that EEOC recommendation had any validity with the courts that led to the employment provisions in GINA, maintaining the employment provisions within GINA. So that's, of course, a possibility. I think a more likely potential avenue for legal redress might be a situation akin to what happened with Burlington Northern Railroad, which was one of the cases that, of course, drove the enactment of GINA, and that had to do with the job-related requirement under the Americans with Disabilities Act. Under the Americans with Disabilities Act, in terms of current employees, you cannot, as an employer, acquire medical information unless it is job-related. And that is a very specific standard that for which there has been plenty of case law to define. In a situation where an employer might be acquiring genetic information where it is not job-related, which would be, frankly, many situations, if not most situations, where an employer might try to acquire genetic information. The fact that they might, want to save money on their health insurance would not meet the job-related standard, certainly. Then they might have redress under the ADA, and I would certainly suggest that they do so. And GINA, by the way, does not prevent multiple claims to be brought under different acts from the same discrimination claim. So an individual could bring a claim under both GINA and the Americans with Disabilities Act if the circumstances of their claim were addressed by both acts. So that's also a possibility.